rely on to challenge adoption bans in states like Mississippi, Virginia, and Utah. So I'm going to simply I'm going to read a little bit of the opinion here, and it says, Chief Justice Berger, under the Berger Court, which upheld sodomy laws in 1986, delivered the opinion of the court. We granted certiorari to review a judgment of a state court divesting a natural mother of the custody of her infant child because of her remarriage to a person of a different race. When petitioner daughter in September 1981, the father sought custody of the child by filing a petition to modify the prior judgment because of changed conditions. The change was that the child's mother was cohabitating with a black man, Clarence Palmore Jr., whom she married 2 months later. Additionally, the father made several allegations of instances in which the mother had not properly cared for their child. After hearing testimony from both parties and considering a court counsel's investigative report, the court noted that the father had made allegations about the child's care, but the court made no findings with respect to these allegations. On the contrary, the court made a finding that there is no issue as to either party's devotion to the child, adequacy of housing facilities, or respectability of the new spouse of either parent. The court then addressed recommendations of the court counselor, which made an earlier report in another case coming out of the circuit, also involving the social consequences of legal marriage. From the vague reference to that earlier case, the court turned to the present case and noted the counselors recommend style unacceptable to the father and to society. The child is, or at school will be, subject to environmental pressures not of choice. The court then concluded the best interest of the child would be served by awarding custody to the father. The court's rationale contained the following: the father's evident resentment of the mother's choice of a black partner is not sufficient to wrest custody from the mother. It is of some significance, however, that the mother did see fit to bring a man into her home and carry a sexual relationship with him without being married to him. Such action tended to place gratification of her own desires ahead of her concern for the child's welfare. This court feels that despite the strides that have been made in bettering relations between the races of this country, it is inevitable that Melanie will, if allowed to remain at her present situation, attain school age and thus more vulnerable to peer pressure, suffer from the social stigmatization that is sure to come. So, if we were to place sexual orientation in there, I'm pretty sure that some courts would agree with the court's findings. But I feel that the Supreme Court overruling and reversing that decision, that because of social stigma, Melanie should not remain in her current house or in her current home with two loving parents who happen to be of different race. That definitely, I feel, can tie into gay adoption. And I submit that not placing a child with a couple that is ready and qualified, other than the fact of an unfair law stating that now, because they are two men or two women, and they cannot be legally married in their state per constitutional amendment or statute or whatever it be, that they should not have custody of or even attain a child, custody of a child, because of the simple fact that they are gay or lesbian. That is definitely something that a rational court would throw out, because of the simple fact that every study that is not flawed methodologically, or the methodology is not flawed, in other words, they've said the same thing, that the content of their child's character is not influenced by the parent's sexual orientation. And Zach Walls, actually, he said that too. But it is true. And the simple fact that stigmatization of a person does not lead anyone to lose custody of their child. In fact, I was stigmatized because I was fat and with glasses. So does that mean that my mother should have lost custody of me because of the societal pressures? Now, because of the societal pressures, I believe that the court got that right. But of course, the high court the Supreme Court did not hear of a child. So maybe they're not ready to address that yet, and they're leaving it to state courts right now, at least. But anyway, this is a very good case. This is a solid case that comes from a high court that should be cited in any and all adoption cases, adoption of course, you have to qualify, but those who are qualified, but the only difference is that they have matching hoo-hoos or ha-has, that's a mess because of the simple fact that there are so many children out here, and one person wrote something that said that placing them in households with gay parents automatically takes away from married men and married heterosexual couples. But the problem is most married heterosexual couples will probably not adopt many of the children that would be adopted by gay and lesbian couples, such as the Gills, for example. They challenged Florida's adoption law, and they won that because there was no rational basis to deny a gay or a lesbian couple the ability to adopt, because they would be qualified if they were married to a person of the opposite sex. And in Florida, the same-sex or marriage equality is not legal down there because of Amendment 2 that passed in 2008 along with Proposition 8. So anyway, I feel that this is a great case for to be cited for an adoption ban, because they decided race and social pressure is not a reason to deny custody to an individual. It says it indicts the society more than it indicts that parent and just the simple fact that they fell in love with someone of a different race. So everybody have a great day, and let me know your thoughts on this case and what you think, if you think that is valid. And you can Wikipedia it, and it will. You should be able to read the opinion if you should so desire. Have a great day, YouTube, and I'll see you later.